What you just said about the towns opening up the purse strings and letting the money flow, I've been to several presentations in several different towns that you know, or maybe you don't know. I'm very active in natural gas development. I'm very proactive. And I'm not a large landowner, I only have 5 acres, but I purchased myself 50 acres off another person on their land for their mineral rights. Which means if they don't allow it, if the town does ban it, that's a total takings of my right. It's not a partial taking.
Yeah.
It's a total takings in my case.
That's a great point, because a lot of times we'll get in these talks and we'll bring up regulatory takings, and the advocates of the bans will say, that isn't gonna happen. Because, for example, like Jennifer Huntington in the Dryden case, or in the Middlefield case, you know, the argument of the pro-moratorium people is that you haven't taken everything that Jennifer has. You're only telling her that she can't use her mineral rights, therefore you're not open for the regulatory takings.
Right, but that's not the case.
Well, it's not, you know, I advise my clients to take their mineral rights, their property, sever their mineral rights, put them into an LLC, a distinct legal entity or person, and then if the bans come through, we will be able to sue the town, because all that entity owns are the mineral rights. Also, there's a big gorilla out there that happens to have, all he owns is mineral rights. That's called the gas companies. Now, the gas companies are kind of busy right now. They're in Ohio and Pennsylvania and hitting oil. Yeah, but just because they're not interested in New York State right now, doesn't mean that they won't come with their stick later.
Would you define takings, please?
Typically, a takings is when someone comes in and takes property that belongs to a private individual and takes it for the good of the community. For example, let's say I own a house, and this community decides that they'd like to make a park on my property. What they do is they come in and take the property through eminent domain, and then in doing so, they have to compensate me, because they're taking private property from an individual and giving it to the public for public good. Well, that's fine, and they typically have that power, but they have to compensate me. All right, now, regulatory taking, what we're talking about, is when a regulation comes in and effectively does the same thing. Now, typically, if it's a partial taking, meaning that they've only taken a bundle of your sticks in your bundle of rights, then the courts have said, you know what, that doesn't require compensation because you haven't been denied all use of your property. But when they come in, like under the Pennsylvania coal case, and in that case, it was decided by the Supreme Court of the United States, they came in and took the coal company's rights to do all their coal mining. It was a complete regulatory taking, and the court held that you have to, municipality, state, public, you have to compensate them.
Is there a distinction for speculative takings?
I look at it, you know, bottom line, if I was going to present a talk on regulatory takings, it'd probably take me an hour or more to go through. I'm not here to claim that I'm a constitutional lawyer. I'm not here to claim that I'm even a municipal lawyer. All I'm giving you is a bird's eye view, free of charge, of, you know, this is a little bit more complicated than the advocates of the bans and moratoriums are trying to sell. I'm not telling you that I'm an expert in every area of law. I'm not. What I do is oil and gas law. But I'm telling you that my cursory look at these bans and moratoriums, red flags are flying up. So to answer your question about all the details about the takings, I'd have to really look into it probably more. I'm not claiming to be an expert in regulatory takings. Does anybody in this room want to try to answer a question? Yeah.
I was happened to be at a meeting just
Right.
recently of
Right.
the Association of Towns, and it was a whole day on hydrofracking, and it was very balanced presentation, maybe more pro-gas than
Right.
anti-gas. It started with Chesapeake, and this question came up about lawsuits,
Right.
the kind of thing we're talking
Right.
about now. And I believe, I won't swear to it, but I'm almost positive, it's the lawyer for the Association of Towns,
Towns.
said that he thought there would be almost no chance that you could win a lawsuit unless you got to the point where permits had been issued. He said, once permits are issued, if you allow gas drilling in, if you, for instance, if you don't have a moratorium and a permit is issued, at that point, if you try and stop that well, you could be sued.
I mean, I look at it like if a gas company has come in and spent millions of dollars on leases, and the only reason why they put that money on the table was because the United States allowed that to happen for the last 80 years, and so it was a reasonable thing to do, they always do it, and then all of a sudden a municipality or a state says, you know what, nah. Typically the state and the municipalities, the federal government respects contracts. And so to me, to argue that they haven't had a valuable resource taken from them would be a stretch. But like I
This lawyer
said,
said
I'm not an expert in municipal law, and by all means, every town board that's considering any of these things, you have a town attorney, you have probably the board of municipal people, resources that you can go to and ask these questions. All I'm trying to present here is that there is another side of the argument. And like we all know, the law is never black and white, and you just got to keep that in your blinders. I'll be right with you in the back.